Good evening, everybody.
Good evening, our Patriot family, and welcome to another episode of the Fight for Patriotism, where we discuss the Constitution and how we can use it to get our beautiful country back from this tyrannical government we are under. On tonight's episode, we will be discussing Amendments 7 and 8 under the Bill of Rights of the Constitution. I'm your producer, host, and patriot brother ▲ and with me is your patriot brother Angry Conservative. I'll say the Bible verse of the day, play my introduction, and then check on how our brothers are doing. The Bible verse of Thursday, August 4th, 2022 is, "But I tell you, love your enemies and pray for those who persecute you." Matthew 5:44 NIV.
We need you now. We need you now. One day, one day, one day, I hope you see the truth. This puppet show stays on because of you. We've been dancing with the devil way too long. I know it's fun, but get ready to pay your dues. Oh God, come back home. This crazy world is filled with liars and abusers. We need you now before we're too far gone. I hope one day they finally see the truth. God, we need you now.
How are you doing today, brother?
I am doing good. It's been an exciting lot of news coming out right now, but that's a whole different story. And Zach, how the heck are you doing? I'm not gonna ask this. Everyone in chat, how are you guys doing? I hope you're having a wonderful evening, because we are getting into a little more of these amendments on with this Constitution. Tonight we are doing number 7 and number 8. So, Zach, did you even read did you even study for this? Or did you just pick out the videos and decide not to actually look into what they were? Always have to have fun with him. But
I definitely do my research beforehand.
Zach, I know that, but I have to pick on you a little bit. Come on. What kind of big brother would I be if I didn't pick on you? And you know I'm telling the truth with that one. But I hope everyone in chat is having a wonderful day. And 7 and 8 are pretty much dealing with the courts again. I know we did a couple last week. 7 and 8 are dealing with the courts again. 7 is dealing with pretty much if you sue if you sue somebody and you sue them for more than $20. That's pretty much that's pretty much almost every lawsuit that I've ever seen. Just saying, I've never seen a $20 lawsuit. I don't think it's worth going to court over $20. But that's a whole nother story. Zach, would you sue somebody for $20? Would you sue somebody for $100? What's the highest you would not sue somebody for?
250.
All right. Because the Seventh Amendment, and get our video ready. I will read the Seventh Amendment because this is how we do it. Hey, Bebo. Seventh Amendment. In suits at common law where the value in controversy shall exceed $20, the right of the trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of the common law. So, in other words, what it's saying, if you have a trial by jury, you can't actually have another trial, and with I won't actually say her name, with all these appeals, they shouldn't be going up the line because the Seventh Amendment says if it's a trial by jury, you have no recourse. So let's go, Zach. Let's get into this.
This is Kim from Khan Academy. Today we're learning more about the Seventh Amendment to the U.S. Constitution. The Seventh Amendment guarantees the right to juries in civil cases when the value in controversy is greater than $20. To learn more about the Seventh Amendment, I talked with two experts. Renee Lerner is the Donald Philip Rothschild Research Professor of Law at George Washington University Law School. She specializes in U.S. and English legal history, and she's written extensively about the history of American juries. Sudra Thomas is the Pierre and Sarah Peterson Professor of Law at the Illinois College of Law. Her research interests include jury provisions in the Bill of Rights, civil procedure, and employment law. So, Professor Thomas, can you tell us a little bit about why the framers were so interested in protecting this right in particular?
Historically, there were juries in England, and a lot of our Constitution is based on what occurred in England, because, of course, that was our historical origin. And so colonists were really familiar with juries, and they knew that the jury restrained government and preserved liberty. And they also knew what could happen without juries. And so because of this history, juries were really important to Americans, and they put it in the Declaration of Independence.
And the framers in general were very enthusiastic about juries. One of the reasons was that juries had been important in helping to nullify British laws that the American colonists didn't like. So an example of these laws is the customs taxes. These were taxes on shipping and were very unpopular, especially in New England. And what would happen is merchants, the Boston merchants, were supposed to pay a customs tax on merchandise that they imported into Boston and also, in certain cases, exported. What would happen is these Boston merchants would try to import goods and not pay the tax. And sometimes they would get caught by customs inspectors. If a customs inspector caught one of these merchants trying to smuggle in goods, the customs collector would seize the ship and the cargo and hold it essentially for ransom. The customs inspector would then bring an action, a lawsuit, against the ship and the cargo, in a court called the Court of Admiralty, which was a type of court that sat without a jury. And the judge in the Court of Admiralty would ordinarily require the merchant to pay a large fine in order to get back his ship and his cargo. So what the Boston merchants started to do, they were deeply unhappy about these fines. They would bring an action in a court that sat with a jury. It was an action for trespass against the customs inspector.
They knew that juries could be really useful because, for example, there was concerns about protecting litigants from bad laws, also concerns about actions by the executive, and they were also concerned about corrupt and biased judges. So for all of these reasons, there was a real value put on civil juries.
Just for our general information, how exactly is a civil trial different from a criminal trial? When in a civil trial, someone is suing and wants damages for something that went wrong. So if, for example, you're in an employment situation and you allege your employer discriminated against you, you can bring a civil case and you can try to get damages or money for the wrong that was committed against you. In that type of case, people who are trying to prove the case have to prove by a preponderance of the evidence that this is what happened to you, that discrimination occurred. Then in the criminal context, on the other hand, someone is accused of doing a crime, and sometimes there's a grand jury that decides whether that case should proceed against you, and then a criminal jury decides whether or not you committed that crime, and they have to decide by beyond a reasonable doubt. And so the standard is different. It's for criminal cases, it's beyond reasonable doubt, versus in a civil case by a preponderance of the evidence. So it's a higher standard to prove someone is guilty of a crime than in a civil case to actually win. So you see this in the O.J. Simpson case, where he's not convicted, but they actually sued him in a civil case, and they actually won, and there were different standards. You kind of see throughout the 4th through 8th Amendments, which deal with the protection of the accused, quite an emphasis on juries. So why were the framers so keen on juries?
In the Revolutionary era in particular, when tensions between the American colonies and Britain were very high, juries were one way that Americans could get popular representation in government. They were not allowed to elect members of the British Parliament. They did elect members of the colonial legislatures, but increasingly the British government was taking power from the colonial legislatures. So this was a way that without an elected legislature, the colonists could get representation. And John Adams wrote a very interesting passage in his diary in 1771. He wrote that juries were like popularly elected legislatures, that they served that function in the American colonies.
There were some concerns about protection for debtors, and that was a big issue at the time. And there were arguments that juries could really protect litigants from bad laws that the legislature passed, from actions by the executive, and from potentially corrupt and biased judges. So it wasn't the case that the framers believed that the jury was actually perfect, but they thought that the jury was the best decision maker.
So it seems that the 7th Amendment has a very specific origin in the history of the Revolutionary War and in some things that were very dear to the founders. What are some of the ways that it has kind of grown and changed in the years since then?
So there is, as you see in the amendment, a $20 amount in controversy requirement is what we call it. And that remains in force today, even though there's been considerable inflation. But still, we've stuck with the $20 limit. The difficulty is today that very, very few cases go to juries, and that is true of the federal courts and also the state courts.
And that's one of the astounding things that many people don't know about, that less than 1% of civil cases, and we have the federal courts as well as the state courts, but in both of those venues, federal courts and state courts, less than 1% of civil cases are tried by juries.
Wow. So what happened there? How did we get from a point where the majority of the cases went before a jury to less than 1%?
One thing that's affected how many cases go to a jury is that judges now have more power to resolve disputes at an early stage. Parties can file a motion to dismiss the case if they argue that the other side did not have a claim that would hold up under law. Judges can dismiss a case if they find that that's correct.
And around the 1930 period of time, you actually see a number of decisions against jury authority, where the Supreme Court actually had ruled in favor of jury authority on the exact same issue. And so something's going on in this time frame around the 1930 period of time, and it's not exactly easy to figure out what that is. But some of the things that I've seen in some of the public documents that are out there, you actually see comments, including by a former Supreme Court justice, saying that, judges are actually better than juries. And a New York State judge stated around this time, yes, a judge should be preferred to a jury. And so that's certainly part of what's going on in the story. And then part of what was going on in the story may be to do with the juries getting more diverse around this period of time, and maybe there's an effort by other certain parts of society to not want diverse juries to decide their cases. So these are just a couple of different ideas that I think are contributors to why juries decide few cases today.
Interesting. And so by this diversity, do you mean like diversity of people from different classes or different genders or different races? What kind of diversity is entering in that time period?
Particularly, we'd be talking about sex and race. Yeah. But I think class is definitely, part of that today as well. And then another example that, is something that I've spent a good amount of time in my career talking about is something called summary judgment. And so summary judgment is a procedure where a judge can decide what a reasonable jury could find. And if the judge decides a reasonable jury could not find for the person who brought the case, the judge can dismiss the case. So someone brings a case for employment discrimination, and there's discovery, and that is, documents being exchanged between the parties and depositions or questions being asked between different witnesses. And so then an employer can say, okay, you accused us of employment discrimination, but we think you don't have enough evidence. And judge, we think that no reasonable jury could find for this employee. You should order summary judgment for us and throw this case out of court. And what has actually happened is in over 70% of the cases where an employer makes a motion for summary judgment in an employment discrimination case, that case will be dismissed in whole or in part.
So judges can, in certain cases, end the case before it gets to a jury. But by far the most common way that a dispute ends is by settlement between the parties. What has encouraged settlement is that it's much more expensive to bring a case and go to jury verdict today than it was back at the time of the founding. One of the reasons it's so much more expensive is that we now have a system of what we call discovery. That is, the parties can ask for information from each other before the trial. They can formally question witnesses, they can ask for documents, they can require questions to be answered. All of that goes on before the trial, and that's expensive to do. And they want to save money. They want to save money that's involved in this pretrial discovery, and they want to save money at the trial. And so they go ahead and they settle. the reason it's so important for the parties to save money is that in our system, each side in a dispute, in a case, has to pay its own legal fees, even if they win. And so the parties have an incentive to settle the case. That way they save expenses, and also they get a predictable result. Many parties are afraid of going before a jury because they don't know what the result will be. For all these reasons, settlement has become very important, much more so than it was at the time of the founding.
So we've learned that the Seventh Amendment's protections for jury trials in civil cases derives from the context of the Revolutionary War, when colonists felt that juries were perhaps the only way they could have a voice in the law. Despite this protection, fewer than 1% of civil cases go to trial today, since trials have become prohibitively expensive and their outcomes are unpredictable. To learn more about the Seventh Amendment, visit the National Constitution Center's Interactive Constitution and Khan Academy's resources on U.S. government and politics.
Hey, Zach, was you enjoying the chat there for a minute? But that, like it said, like at the end of the video, it said most trials get settled outside of court because they do have to pay for their own attorneys. They do have to do all of that. It's not an easy process to actually go through. And then you, on top of it, most courts, I know here in Alabama, it's like $300, $350 to file a lawsuit against somebody. Yes, I'm not kidding you. But yeah, that's the thing about it. Most people don't realize that them lawsuits, them multi-million-dollar lawsuits, when they actually get a verdict out of them, the lawyer usually takes about 1/4 of it. But that's the thing about it. That's why people do not want to actually go to trial during a lawsuit, because they have to pay for their own attorneys in most states. But if I ever sued someone, I would actually be my own attorney, but that's a whole nother story. And go ahead, Zach.
It's crazy how discovery costs the most.
Yeah. Yeah. Because it's not cheap. It's not a cheap, and does anyone have any questions on the Seventh Amendment or what it pertains to? Because we're going to try, we want you guys. But yeah, the Seventh Amendment, there's really not much to be done with the Seventh Amendment because it's a civil trial, it's civil cases. But I will say this now: if you get sued and you lie on the stand, you can actually go to jail for it. You can actually be prosecuted for it. Yeah. Because there's a story going around right now most people probably know about. But yeah, that's the thing of.
Because it's perjury.
It's perjury. So yes. Because even in a civil case, when you go up on that stand, you're still under oath. and I'm going to say this now. I said it in chats, but since I'm up here and I will say it for you, Garrett, happy birthday. I hope you had a wonderful day. I know you got some presents. We do appreciate you and enjoy you, all the things that you share. I hope you have a wonderful birthday from me and Zach. Now, number 8. Zach, I'm going to ask this while I'm reading it. You can type it up. What do you know about the 8th Amendment? What do you know about this 8th Amendment? Let's see. Excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishment inflicted. Because most people, when they say the 8th Amendment, they always go to that very last one. Cruel and unusual punishment inflicted. That's what most people actually think the 8th Amendment's all about. Actually, no, it deals with bail and all that fun stuff too. But go ahead, Zach.
It's about the set bail and that stuff.
That's how, and I'm just going to throw this out there. That's how the state of New York and the state of California can have a cashless bail. That's how they can do it, because the 8th Amendment does not say if that has to be, it says no excessive, but that excessive can mean anything. So that's the thing about it. Man, very true. Very true. And I'm not going to say this now. Not necessarily, because he did murder 2 people. They did think the reason they arrested him, and it's been proven false, they thought he murdered 2 people, but that was all a lie. So I can understand that bail. So that might not actually have been an excessive bail. So they thought he murdered 2 people. So that's where you get into this. But Garrett, we're not going to get into that, but let's get into this 8th Amendment, because we're not going to actually be here all that long tonight. So hit it, Zach.
Kim from Khan Academy. Today I'm learning about the 8th Amendment to the U.S. Constitution, which prohibits the government from imposing excessive fines and bail or inflicting cruel and unusual punishment on individuals accused or convicted of a crime. But what counts as excessive or cruel and unusual? To learn more, I sought out the help of 2 experts on the 8th Amendment. John Stiniford is the Assistant Director of the Criminal Justice Center at the University of Florida Law School. John Bessler is an Associate Professor of Law at the University of Baltimore Law School. So, Professor Bessler, why were the framers so keen to include the 8th Amendment? Why did they want to protect these rights in particular?
Well, these rights were actually enshrined in the English Bill of Rights of 1689. And so when the Americans got into a dispute with Great Britain, they decided they wanted to have the same rights that Englishmen had. And so it was not too surprising that when George Mason actually wrote the Virginia Declaration of Rights in 1776, that he looked to English law to see what rights the English had, because he wanted exactly the same rights. And so this 16 words in the 8th Amendment have been subject to a lot of controversy over the years. But I think one of the reasons that the founders wanted this was that, like the English, would have had problems with the monarch imposing excessive bail, excessive fines. inflicting cruel and unusual punishments. The founders also knew that was a risk, that there was abuse from the government in the United States, and so they also wanted those rights. Because originally in the Constitution, these rights were not protected against. And the Bill of Rights was ratified in 1791, which ensured that there would be protections against these cruel and unusual punishments and excessive bail and excessive fines.
If you look at the Eighth Amendment, there's 3 clauses, right? The excessive bail clause, the excessive fines clause, and the cruel and unusual punishments clause. And these all have one thing in common, which is that these are all penalties, essentially, that the government inflicts on people, usually as the result of either being accused of crime or of being convicted of crime. So if you've been arrested, you're waiting for trial, very often your only way to get out of jail before trial is to make bail. And of course, after you've been convicted, the court might impose a fine on you or some other kind of punishment. And so the Eighth Amendment is designed to prevent the government from doing things that are excessive. You know, when the government punishes a person, that's the most coercive thing the government does short of war, right? Other than, shooting you in battle, picking you up and throwing you in a jail cell is about as bad as it gets. And so the framers wanted to make sure that we had constitutional protection when it comes to criminal punishment.
So in a lot of cases in the Bill of Rights, you see the framers reacting to some historical evil that they hope to prevent. For example, the Third Amendment says you can't quarter soldiers in private citizens' homes because that had been such an important tipping point in the American Revolution. Was there something that the framers had in mind as a particular historical evil that they wanted to prevent?
Well, there was some historical evils, and the English Bill of Rights went into place in 1689, and when that went into place, there was actually a controversy in England around a person by the name of Titus Oates. Titus Oates was somebody who had made a false accusation, had committed perjury, resulted actually that allegation, the execution of 15 Catholics, and the plot that he had alleged was one to assassinate the King of England.
The question is what to do with Oates, right? Because as a sort of a moral matter, he's about as bad as it gets. In fact, in 2005, English historians voted him the worst Briton of the 17th century and the third worst Briton of the last 1,000 years, or something like that. So a very bad guy. You could think of him as a sort of a serial killer. But the problem is that the actual crime he committed was the crime of perjury. And even though his perjury resulted in the deaths of many innocent people, nonetheless, he could only be convicted of perjury, which at the time was a misdemeanor, which meant that he could not be executed for his crime. So when it came time for his sentencing, the judge, Chief Justice Jeffreys, who was a famous hanging judge from English history, says to Oates, well, Oates, we can't take your life, we can't take your limb, but we have something special prepared for you. And it turns out that what they had prepared for him was, number one, a huge fine. They fined him like 2,000 marks. They sentenced that he be dragged across the city of London while being flogged. He was dragged from Aldgate to Newgate while being flogged. And then 2 days later, just as the scabs were starting to form on his wounds, he's dragged back across the city of London from Newgate to Tyburn, again while being flogged. Many people think the hope was that he would die from the flogging, but like a cockroach in a nuclear war, he survived.
This punishment was actually a very severe punishment, and after the English Bill of Rights was promulgated, the Titus Oates' punishment was challenged, and some of the members of the House of Lords actually called the punishment barbarous, inhuman, and unchristian, and contrary to the English Bill of Rights, and said that there was no precedent to warrant the punishments of whipping and committing to prison for life for the crime of perjury. This punishment was eventually remitted in the sense that Oates was later released.
Although the House of Lords refused to vote to suspend the judgment against Oates because they hated him so much. They said, so ill a man shouldn't get the benefit of any relief. But they all agreed that the punishment was cruel and unusual. And what's interesting is in the debate, they say things like, this punishment is contrary to law and ancient practice. It is without precedent, and it'll be a bad precedent for the future. So in other words, it's cruel, and the way we know it's cruel is because it's so much harsher than has previously been inflicted for the crime of perjury, right? So the Oates case shows us that when the words cruel and unusual were first used. They were used to describe punishments that are harsher than the common law would permit, or harsher than long-standing prior practice would permit. And this means that, among other things, the cruel and unusual punishments clause is not limited to gruesome punishments like torture and the rack and all that kind of thing. Because, in fact, the punishments inflicted on oaths, although they were very harsh for the crime of perjury, were not as harsh as some other punishments that the common law permitted for other crimes, like treason.
Wow. So that tells us a lot about the English context of cruel and unusual punishment. Do we know what cruel and unusual meant to the framers of the U.S. Bill of Rights?
So punishments were cruel and unusual, again, if they're too harsh in light of longstanding prior practice for the crime for which they're inflicted. There's another problem with statutory law or with decisions of a judge or a king or a president, for that matter, that's also really relevant when we think about the Eighth Amendment. And that is, sometimes the government gets really mad at someone. They either think of a person as an enemy of the state and they want to inflict the worst punishment they can on that person, or perhaps there's a panic about a certain group in society. So, for example, in American society recently, there have been panics about drug crime or panics about sex offenses. And every time that happens, the government tries to respond with new forms of punishment that are much, much harsher than what came before. And so the insight behind the Eighth Amendment is that when the government wants to inflict a new punishment, you have to compare it against long-standing prior practice. That is, you have to compare it against the common law, right? So the common law was called the law of custom and long usage, right? So if something comported with the common law, it was usual. If it was contrary to the common law, it was unusual. And that's where we get the phrase cruel and unusual punishments. It's basically punishments that are cruel in light of or in comparison to long-standing prior practice. So the basic point of the Eighth Amendment from a historical point of view is to prohibit the government from innovating in a cruel manner, making up new cruel punishments in response to some actual or perceived provocation by a criminal.
When the U.S. Bill of Rights was adopted many years later, many decades later, they had their own issues that they were struggling with. And so the history shows that the American founders probably meant something different than the English meant because it was done over 100 years later, but no one knows exactly what was meant when they adopted that wording. To give an example, when the bill was debated in Congress, a delegate from South Carolina, representative from South Carolina, said that he objected to the words "nor cruel and unusual punishments" because he said the import of them was too indefinite. And there was another legislator, Mr. Livermore from New Hampshire, who said that the clause seems to express a great deal of humanity, in which account I have no objection to it, but as it seems to have no meaning in it, I do not think it necessary. What is meant by the terms excessive bail, he asked. Who are to be the judges, he also asked. What is understood by excessive fines? It lies for the court to determine. And so that's really where we are today in a lot of ways. The court is still deciding, in this case, the U.S. Supreme Court is still deciding what the Eighth Amendment language actually means today.
The modern case law, especially starting in the 1970s, revolved a lot around the death penalty. And so the question was, is it still okay to execute people for various crimes short of murder? Since the 70s, the court has continued to do that in a number of areas. So it said you can't execute the mentally disabled anymore. You can't execute minors. You can't execute anyone for a non-homicide offense. Although it's limited the death penalty in the name of current standards of decency, it's really not clear how the court has set about to determine whether a punishment meets current standards of decency. When a court is kind of on its own saying that a punishment violates current standards of decency, despite the fact that most democratically elected legislatures actually approve the practice, then it looks like the court's acting as sort of a political body. It's sort of led the court to ignore what I think is the real danger of cruelty, which is that when there's a public panic and the legislature responds by ratcheting up punishment to new and unprecedented levels of punishment. And that's actually happened quite a lot in the last 40 years. And every time there's a panic you predictably see the legislatures coming up with new punishments that are much, much harsher than what came before. And so, for example, with regard to sex offenders, there are now a bunch of states that actually impose chemical castration as a form of punishment for sex offenders. Now, castration as a form of punishment fell out of usage in the 13th century. We're literally getting medieval on sex offenders, but the court can't do anything really to stop it, or at least hasn't, because these are very popular forms of punishment. Everyone hates sex offenders.
The UN has actually decided that anything more than 15 days use of solitary confinement should not be permitted. Justice Anthony Kennedy actually raised the issue of solitary confinement in a recent opinion he authored for the Supreme Court. He actually raised the issue on his own at oral argument at one point, talking about how long people actually spend in solitary confinement in American prisons, including on death row. And you have cases actually where people are spending not just years, but sometimes decades on death row in these kinds of conditions. Justice Breyer just wrote a dissent in a case where the person had been on death row for more than 40 years, so literally 4 decades in these kinds of very harsh conditions of confinement. Other countries have decided that is not something that they want to permit. And they've actually set out a rule that anybody that's on death row for a certain number of years, for example, would have their sentence commuted to a life sentence because of the psychological aspect of sort of waiting for one's own death.
In the Bill of Rights, this is the last of 4 amendments, actually, that are concerned with protections for the accused. So why do you think there's so much in the Bill of Rights about the justice system? Were the framers particularly interested in making sure that the accused had rights?
Yeah, they were. And in particular, Americans were very devoted to the idea of the common law as a source of rights, right? In fact, that's why we had the American Revolution in the first place, was that England was denying to Americans common law rights, like the right not to be taxed without representation in Parliament, but also more specifically to the criminal law, they were denying them the right to a jury trial in criminal cases. And so Americans wanted to make sure that when the U.S. Constitution was adopted, that those common law rights that had built up over time in England would be preserved in the new American constitutional order. And many of those rights had to do with criminal law, both criminal procedures and to some degree substantive criminal law, and of course criminal punishments. And again, the reason gets back to sort of what I said at the beginning, which is that when the government punishes someone, that's about the worst thing it can do. And because the early Americans who framed the Constitution were very powerfully concerned with liberty, they wanted to make sure the government would preserve their liberty, protect their liberty, and not become tyrannical, right? And so one of the main ways that they wanted to make sure this happened was by limiting the power of the government to punish whoever it wanted to for any reason that it wanted to. And so we have really the majority of the protections in the Bill of Rights have to do with the protections for criminal defendants.
What about excessive bail and excessive fines? How can we define what kind of financial penalty is proportionate to a crime?
The courts have said, essentially, they've looked at dictionary definitions. Excessive means more than is necessary. One of the core principles actually go back to look at ‿ work in the 1760s. He talked about this idea of a scale of crimes and a scale of punishments. And he said that there should be proportionality between the two. And so that proportionality principle is one that we're really still wrestling with today.
Now, the point of bail is not to punish someone, but rather just to make sure that they will appear at trial, right? And so the amount of money you have to impose for bail doesn't depend so much on what crime you committed, but what your financial resources are, right? It depends partially on the crime too, but largely on your financial resources. So the amount of money necessary to make sure that a poor man appears at trial is probably going to be much lower than the amount of money necessary to make sure that a rich man appears at trial. And so it's a standard that depends partly on the nature of the crime, but also partially on the nature of the offender.
I imagine that what seemed like cruel and unusual punishment in the 18th century might not be what we consider cruel and unusual today. For example, we don't do whipping as a punishment anymore. How has what counts as cruel and unusual punishment changed over time?
The law really changes gradually over time, as you know, and so when you look back at history, they actually had a large collection of pretty gruesome punishments back in the 18th century. And we had non-lethal corporal punishments. They used things like branding people. They, of course, were whipping slaves back then. Slavery was still around. This is well before the Civil War ended the institution of slavery. And we also had things like ear cropping. People would, get their ears cut off. In the Crimes Act of 1790, which was passed just the year before the ratification of the Eighth Amendment, the Congress actually authorized public whipping, lashing of people, and it also authorized the pillory, the same punishment that had been used against Titus Oates. So there was these non-lethal corporal punishments, and really the death penalty is sort of the last vestige of a bodily punishment that the Eighth Amendment. The Supreme Court has read the Eighth Amendment to allow the use of capital punishment. That issue is still a very live one before the Supreme Court. We're now seeing challenges about lethal injection protocols. We saw a challenge to a protocol in Kentucky in 2008. We saw one to a protocol in Oklahoma in 2015. These, of course, are things that the Founding Fathers would never have envisioned.
Lethal injection typically involves a 3-drug cocktail. So there's a barbiturate, which is supposed to put you to sleep. There's a paralyzing agent, which paralyzes your body and also stops your lungs from moving. And there's a heart-stopping agent. Give the offender all 3, and they're supposed to die, quickly and painlessly. But the problem is, if the sedative doesn't put you completely deeply unconscious, then the other 2 drugs are likely to make you suffer quite a bit before you die. And so the question is this cruel and unusual, or is it not cruel and unusual? And to date, the Supreme Court has twice held that lethal injection is not cruel and unusual. And their main reason has been that the state's not trying to torture you to death. And so if maybe you're sometimes accidentally tortured to death, well, that's just too bad. But it's not a cruel and unusual punishment.
So the Supreme Court has approved various methods of execution. At the same time, however, the Eighth Amendment has been read to protect prisoners. So in general, the Eighth Amendment is sort of a protective shield that prohibits prison guards from gratuitously beating up inmates. It requires prisons to provide some level of health care to prisoners because they cannot get it themselves. They're sort of wards of the state once they're put in prison. Requires inmates be fed and sheltered. So in a lot of ways, the Eighth Amendment is a protective shield protecting inmates. But then in the use of the capital punishment, it becomes what I like to call kind of a Dr. Jekyll and Mr. Hyde kind of jurisprudence that the Eighth Amendment has right now.
So we learned that the Eighth Amendment seeks to limit the power of the government in meting out punishment to people who have been accused or convicted of a crime. Although it's hard to tell exactly what constitutes excessive fines or bail, in general, it's accepted that those punishments should be proportional to the crimes in question. Today, one of the biggest debates concerns whether or how the Eighth Amendment may limit the death penalty. To learn more about the Eighth Amendment, visit the National Constitution Center's Interactive Constitution and Khan Academy's resources on U.S. government and politics.
Hey, good evening, everybody. Sorry I'm late.
But I can you bring Slow Country's comment about Nadler, please? That goes against my Eighth Amendment. That's cruel and unusual punishment. No, the other one, the one that about the clothing line.
Oh, I saw that. Yeah.
That goes against my Eighth Amendment. That's cruel and unusual punishment. Come on, people.
Hey, I tell you what, that lady said one thing that it made me flash back. We have a weekly newspaper here in the county. Every small town's got that weekly rag that comes out and tells you who went to whose house over the weekend and all that. But they've got a page called Time Past, and they repeated an article from 50 years ago, and this happened when I was in high school, and I remember when it happened. It was actually in that newspaper when it happened. But there was this boy that was in high school. I guess he wasn't 16 years old yet, but he lived across the mountain and went to another school from mine. But he was all the time skipping school. And I guess he lived with a single mother or maybe a grandmother, widowed grandmother or whatever. And people that were raising him had no control over getting him to school. And finally the law stepped in and he ended up in court. And the judge sentenced our local deputy sheriff to physically whip this kid in court. Now, the deputy sheriff was a big man, and his belt was really long. It was like a whip. And he beat that boy's ass right there in the courtroom, and it was still in the newspaper 50 years later. So there you go. Cruel and unusual punishment.
And Zach, you got something you want to say? He's right. Mayhem's right. Because people, and I'm not going to say this because I do know a lot of people.
Back. Hold on, I've got a problem.
I'm not going to say this now. I honestly think they went away with some of those harsh punishment because this is what they wanted. The political establishment wanted this, in my opinion, because they knew if they got away from, and you guys down in the chat, you let me know, because Tom probably didn't grow up in this era, but I remember it. My school told me if my parents punished me for anything that I did wrong, to come to school and tell them, and they would have them arrested. And I'm only in my 40s. Think about that. Zach, did you hear that in school? That if your parents put a hand on you to tell the school? But yeah, that. Did you hear what I said, Mr. Tom?
I missed what you said, sir. Do you mind repeating it?
I don't mind repeating. I remember growing up, the school coming to me and telling me when I started school that if my parents ever laid a hand on me to come to school and tell them.
Mm-hmm.
And that's been about 40 years. That's been over 40 years. That's been over 30 some years ago that happened for me. And go ahead, Zach.
Go ahead, buddy.
I believe the political establishment wanted to weaken this generation so they could control better.
Political establishment or other enemies. But the gist of what you said is correct. They have taken discipline out of the equation and kept them running wild. Thinking back on what your teacher said, I've got a son, 47 years old. He'll be next month. And I had this teacher call. I'm thinking Josh was maybe in 5th grade. And, you know, the lady obviously needed a drink when she got home after dealing with all them kids. And she called me 3 sheets to the wind, and she said, I can't make your son take his hat off in the classroom. And I said, you can't make a boy take his hat off? Why don't you go over there and knock it off? Oh, I can't do that. And I said, I'll handle it when he gets home. And I promise you he won't be wearing his hat in school anymore. There better not be a mark on him. She said, I'll turn you over to CPS. And the next day, I was enrolling him in a Christian academy and taking him out of the public school system. If you can't make a fifth grader take his hat off in class, you got no business teaching kids. That's just how I felt.
And Mayhem, we're not that far in age, are we? But that's the thing about it. People don't realize that the government got interfered with public schooling, got into bed with all of this, and now we're seeing what it's actually done. Because when I look back on that, I'm like, I couldn't believe it. I'm actually older than you. And I remember my teachers telling me that. I'm 41. But yeah, I remember teachers telling me but I also lived in Ohio, and most of my life it was a Democratic governor for most of my life up there.
I came from a little bit different time, man. I'd get my rear end lit up in school, and it's probably a better idea just not to mention it when I got home. Because then I got a problem at home. What did you do? There was no thought it might be the teacher being wrong. It was, what did you do?
Exactly. And Zach, go ahead, buddy.
Oh, trust me, government definitely got in bed with public schools because they don't teach correctly.
And Zach, and I'm going to ask you, you've been over on my channel, you've watched my streams. How much of the stuff that I've shared did you actually know before you actually seen it? Very little is what he's saying. But I grew up in a time when stuff was actually taught. But yeah,
Zach, I really believe it was the communist movement that infiltrated the whole thing first, and then eventually government too.
Yeah.
And got the government support, but the communist movement started creating all these radicals in the 60s on college campuses. And those radicalized
during Vietnam
later went on to become teachers. This is how they infiltrated our school system. Useful idiots, they're called.
They are very useful idiots.
Yeah. Yeah.
But and this is why I love sharing stories from my past, because I grew up in Tom, we're in three different generations.
Pretty much.
You're what, a Gen Xer? No,
I'm a boomer.
You're a boomer.
Yeah.
I'm the oldest millennial, and Zach is a young millennial.
Okay.
Yeah, he's one of the youngest ones. But I'm more of a Gen Xer than I am a millennial, because I have been through a lot more. But the thing about it, we have three different generations, and we all have different experiences going through this stuff. And Zach, go ahead.
Good thing I got out of school before the Common Core bullshit, because I wouldn't take the bullshit.
And this is why I love this guy. He actually tells the truth. Because it's just when you were in school, being spanked was actually allowed, and it was done pretty regularly. And
until you learn your lesson.
And Tom, and let me ask you this. If you told your parents you got whipped at school, you got another one at home.
You know, it didn't really go that far, but I didn't get a lot of sympathy. It was, well, what did you do? You know, tell me you do that.
Hey, BB72. But yeah. Hey, Terry. But that's the thing about it. We all grew up in different eras, and it's like we can see that it slowly went downhill from your generation to mine to Zach's.
Oh, yeah. Oh, yeah. Definitely.
But I want you people to remember, cruel and unusual punishment can be classified in many different ways. For me, cruel and unusual punishment, if someone hurts a little child, and I'm going to keep this family friendly, because I don't know who watches it after we actually do the stream. So I'm going to keep this a little PG. If you hurt a little child, I think something should be taken off. I'm just saying. That's my opinion. I don't think that's cruel and unusual punishment.
Well, you know, they discuss that in the video, and it can be done chemically.
That's
so
true.
There doesn't have to be any gore or blood involved. It can be done. And why not? You're not going to change, so let's fix you so that you can't hurt nobody no more.
Exactly.
You know, the punishment does have to fit the crime.
Because I seen Zach's comment in chat, and he was like, me and him's on the same page with that one. We don't think that's cruel and unusual punishment. Go ahead, Zach.
If adults hurt children, they should be hung publicly.
I got no problem with that either.
That one I will agree with.
That at all.
Yeah, we need that. Hey, I'm going to keep it friendly. How about a firing squad if it's a man? If it's a man. Having a firing squad shoot something. Would that be cruel and unusual punishment there?
Yes, I think it would. Yes, I think it would.
But yeah, that would be. Hey, that would be something the Supreme Court could take up with that one. But that's my opinion.
See, I never felt like punishment should be vindictive.
Wow.
It should be justice. Business. Very business-like. You got to take the emotion out of it.
Now I can understand why you would say that's cruel and unusual punishment. I can, and yeah. I respect that.
Thank you.
Because I've never thought of it that way. But Mayhem has a heck of an idea. And before they get hung, let the community whip them first. Now, that might be going a T-bit over, just a T-bit with the cruel and unusual punishment, but that, I don't know. But that's the thing about it.
See, that goes back to stonings in biblical times. That's a little bit too personal from my sensibilities. Let's just put it that way. If the government's going to get into the business of putting people to death, which they have to do sometimes, it needs to be done in a very matter of fact. You did this. We have to do this.
Mm-hmm.
No hard feelings. It's just what has to happen.
It's just business.
Yeah, it's just business.
It's just business.
That's my opinion.
And since you weren't here, and I'm going to ask you, the Seventh Amendment, what do you think of it?
I got to refresh a little bit, but it had to do with suits at common law.
Yep. The civil cases.
Yeah. And apparently no appeal. although I thought I'd heard about civil suits being appealed. So, I really don't know how much teeth that amendment has. Okay, if it's tried by a jury, and no fact shall be otherwise re-examined. So, but aren't they appealing this Johnny Depp trial right now?
I made that point.
Oh, did you? Okay.
I made that. That was the first point I made after the video. Was technically, according to the 7th Amendment, you should not be but she might be trying to get it on a locality and stuff like that, because there were some things that she didn't, that have come out that she might be able to get an appeal on. But because I think she's going to have to pay the money for one simple fact. She's starting to sell places. I've seen,
there may be procedural appeals, but it seems to me like once the verdict is given, according to the Constitution, that's what it is.
Yep.
So.
But yeah, that was the first point that I made after the video. Slow Country, she has a lot of different nicknames. I figured you'd get a kick out of that one.
Johnny Depp literally did put up with a lot of shit from that woman.
Figuratively and literally. Go ahead, Zach.
Hey guys, I'm going to shout out a really good YouTube channel that I found by Cola. The channel name is Legal Bites. They cover trials and discuss them.
They are. And Zach, can I shout one out that goes on Legal Bites? The guy's name, the channel name is ‏‟ He does a lot of. He did The Rittenhouse. He did AH and JD. I'm not going to say their names because I don't know how YouTube is acting with that, with all of that, but he's done a lot of them. So if you want some good legal perspective, go over and listen to Legal Bites or ‏‟. There's a lot of them tied in with all of that, so there's a lot of lawyers on that.
Is that BYTES?
Yes. They are good. They give you the breakdown and everything. They are very good at what they do. And yeah, they have a few more followers than what me and Zach do, but if we can send them over there and they can get some good content with legal stuff, that's the place you need to go. And Zach, next week we actually finish the Bill of Rights. Because the Bill of Rights is only the first 10 amendments. We are going to keep doing the other 17 after it, but the Bill of Rights will be ended next week. So 9 and 10. I love number 10 because it gives a lot of power to the states that the federal government over the last, I'm going to say the last 30 years that I've seen, have overstepped. It's probably been a lot longer than that, but I've seen it the last 30 years, but
Any last words, my brothers?
We just got started. You quitting already?
You just got started, young man.
Man, I was all into this too. I'm so sorry. Yeah, I picked up on something that they mentioned in the video about how all of these amendments in the Bill of Rights have to do with the courts and protecting the rights of the accused. It's a terrible thing when somebody is wrongly accused. And I think all these safeguards are in place to make as sure as humanly possible that an innocent person doesn't get punished for something he didn't do. And that is really the foundation of our legal system, to not allow that to happen. And on the other hand, the guilty guy should be punished to the absolute maximum that the law and morality will allow. So, yeah, that's all I got to say. Sorry I was late.
But we appreciate your perspective because you are older than me and Zach, and it's kind of nice to have someone with a little more experience with stuff we're talking about, because people can get a better idea of things we've all seen over the time. And I will say this now, Zach, thank you for letting me come up here and joining you on these, because this has been a pleasure. This has been fun, because I love teaching about this Constitution that we want to uphold, that is slowly trying to be taken away from us. So thank you for letting me do this with you, Zach. And Tom, thank you for coming with us.
Thanks
and
for
everyone in chat, thank you for coming. Please like, share, and subscribe. Share this video so people actually know their rights under the Constitution. That's why me and Zach started this in the first place, because we want you to know your rights as the founding fathers have given to us. And Zach, go ahead, bud.
Hey family, thank you for coming and learning more about the Constitution. We need to learn this because we need to take this seriously and overturn the country. Have a great night, family, and I love you all.
Resist.
Good night.
Good night.
We don't trust the news, the government, or pharma. We just want freedom that you have that to offer. We don't want the lies, the politics, or the drama. We just want the life that was promised by our fathers. We don't trust the news, the government, or pharma. We just want freedom that you have that to offer. We don't want the lies, the politics, or the drama. We just want the life that was promised by our fathers. The man on the news says the problem is me. I'm just a small town boy with big American dreams. The world's going crazy.